Good evening, distinguished guests, colleagues and friends. Welcome to the annual Michael Whincop Memorial Lecture for 2021. My name is Mary Keys. I'm the Director of the Law Futures Centre here at Griffith University. I'd like to begin by acknowledging the traditional custodians of the lands on which we're all meeting and to pay my respects to their elders, past, present and emerging. I extend that respect to Aboriginal and Torres Strait Islander friends and colleagues who are attending this event. We're very sorry that it hasn't been possible for us to hold this event in person in 2021, but we are pleased that the lecture has been able to continue nonetheless. And we're especially grateful to the speaker, the Honourable Robert French AC, for accepting the invitation to deliver the Whincop lecture, but particularly for his flexibility in agreeing to do so in the circumstances. This lecture was inaugurated in 2004, a year after Michael's untimely death. Michael Whincop was a brilliant scholar. In his short but exceptional career, he established an international reputation for his path-breaking research in which he applied an economic analysis to corporations law and to private international law. In less than a decade, Michael published 6 books, more than 50 journal articles and book chapters, and won 5 Australian Research Council grants. Michael is still very well known internationally for his research, but closer to home, he's remembered by his colleagues and his former students as being a dedicated and thoughtful teacher. Griffith University is enormously proud of its continuing connection to Michael, and I'd like to particularly acknowledge Michael's sister, Shelley Whincop, who is attending this lecture. I'd like to thank everyone for your attendance this year. It's now my great pleasure to introduce the Vice-Chancellor of Griffith University, Professor Carolyn Evans. Thank you.
Good evening. My name is Carolyn Evans and I'm the Vice-Chancellor and President of Griffith University. I would like to begin by respectfully acknowledging the traditional custodians of the various lands on which we are meeting. I pay my respects to their elders, past, present and future, and extend that respect to all Aboriginal and Torres Strait Islander people. Tonight we are here to honour the late Michael Whincop, a brilliant and leading Australian and international scholar working at the intersection between law and economic analysis, whose life was tragically cut short too soon. Tonight we honour Michael's memory with a lecture by the Honourable Robert French AC. I'm both delighted and honoured to introduce the Honourable Robert French to speak to you tonight on the topic of words in law and rules, the elusive butterfly of meaning. This topic is set to be an engaging one, dealing with the importance of language in law and the risks involved where choices of meaning affect the interpretation and application of the law. As an eminent jurist, this is a topic that the Honourable Mr French is highly qualified to talk about. Born and raised in Perth, he's a graduate of the University of Western Australia in both science and law. Admitted as a barrister and solicitor in 1972, Mr French was then appointed as a judge of the Federal Court in 1986, where he served with great distinction, leading to his appointment as the Chief Justice of the High Court of Australia in September 2008, in which position he served until his retirement in 2017. An active advocate of the rights of Indigenous Australians, Mr French founded the West Australian Aboriginal Legal Service and was the first President of the National Native Title Tribunal. He has held numerous international judicial roles, including as a member of the Supreme Court of Fiji, a non-permanent justice of the Hong Kong Court of Final Appeal, and an international judge of the Singapore International Commercial Court. He was also Deputy President of the Australian Competition Tribunal and a part-time member of the Australian Law Reform Commission. Mr French now holds the position of Chancellor of the University of Western Australia, a position he's held since December 2017, as well as holding positions at a number of other Australian universities. In 2010, he was appointed a companion in the General Division of the Order of Australia for eminent service to the law and to the judiciary, to legal education, administration and legal reform. Please join me in welcoming the Honourable Robert French, who will deliver tonight's Michael Whincop Memorial Lecture. Thank you.
It's a great pleasure to be here to deliver the Whincop Memorial Lecture. I'm only sorry that I was unable to be present in person. But I speak to you from the Hermit Kingdom of Western Australia and from the land of the Whadjuk people of the Noongar Nation. And may I acknowledge any dignitaries who may be there, including the Vice-Chancellor and the Dean, but whom I unfortunately am unable to see. Professor Michael Whincop was a rising young academic at Griffith University when he died tragically in 2003, aged only 34. His impact on his colleagues and the university and beyond was reflected in a moving eulogy for him delivered by his colleague, Professor Charles Samford. He was a person of wide interests, but his scholarship focused on the interactions between economics and the phenomenon we know as the corporation. The achievements of his all too short academic life were prodigious, including 6 books and more than 50 published papers and lectures. The impact of his passing upon his colleagues is reflected in the establishment by the university of this lecture series. There are many lectures given around Australia for jurists and academics, living and dead, but it's an honour to be, I'm not aware of any for a person who was so young when he died, and it's an honour to be asked to deliver the lecture. The series celebrates not only the memory of Michael Whincop, but also the significance of academic scholarship and research carried out by so many brightly burning intellects around Australia. As anyone who read Charles Samford's eulogy would notice, words can move us. They may also empower and constrain. My primary subject today is the meaning and effect of words used in our legal system, including words which confer powers or rights, impose obligations or duties, words which free and words which bind. They'll be found in laws, contracts, wills, deeds, and legal instruments of all kinds. They'll also be found in communications between human beings that are central to the workings of our justice system. They don't operate of themselves, it's human beings who give them meaning and legal and practical effect. And in legal texts, they do that through the processes which we have come to call interpretation and construction. The interpretation and construction of legal texts is located in the larger setting of transmission of meaning in human communication generally. And that larger setting includes oral communication in the justice system between judges, lawyers and court officers and those who are engaged with the system as parties or witnesses or friends or supporters. When parties and witnesses try to convey in their testimony or understand in their listening the truth of events, circumstances, conversations, motivations and intentions, something always seems to get lost in translation. John Wigmore referred to the inadequacies of language in his Science of Judicial Proof, published in 1937. He reproduced there a passage from an article published in 1869 by W.D. Whitney, Language and the Study of Language, which seems apposite even today. This incapacity of speech to reveal all that the mind contains meets us at every point. The soul of each man is a mystery which no other man can fathom. The most perfect system of science, the most richly developed language, leads only to a partial comprehension, a mutual intelligence whose degree of completeness depends upon the nature of the subject treated and the acquaintance of the hearer with the mental and moral character of the speaker. Following that quotation, Wigmore observed, one effect of this peculiarity of language is that in the delivery of testimony in open court, the special conditions often affect the utterance so as to mislead the hearer in the interpretation of testimony. The problem which arises in ordinary communication between fluent speakers of the same language is compounded when parties and witnesses who do not speak with fluency or perhaps at all the language of the justice system try to communicate their truths or understand what is being communicated to them. And when a party or a witness comes from a culture which is not that of the judicial system and its actors, the assumptions and the very process in which he or she is engaged may diminish the capacity of that person to convey true meaning. Interpreter services, however high their professional standards, can never eradicate that kind of difficulty. One has only to point out to the lived experience of many federal court judges over the years dealing with asylum seekers in detention who did not speak English and had no basic understanding of the functions of courts on judicial review. A report prepared for the Australian Capital Territory in the 1980s put it well. Different languages are different worlds. Transferring messages from one such world into another is not impossible, but far from being a simple technical operation, it is a difficult and sophisticated art. Today, there is an increasing level of awareness of the problems of cross-linguistic and cross-cultural interaction in the judicial process. There was a time when interpretation and translation, even from one language to another, was thought to be a fairly mechanical function. This was illustrated by Sir Samuel Griffith's translation of the Divine Comedy. It expressly set out to be literal and to reproduce Dante's original metre. Sir Samuel placed on his title page what he called his translator's slogan, namely that, quote, "A translation should present a true photograph of the original." The results were not entirely happy. A polite reviewer wrote in the English Review of 1912, "Sir Samuel, who has found leisure from his labours as Chief Justice of the High Court of Australia to complete such an exacting task as the translation of the Divina Commedia, speaks so modestly of his work in the preface that it seems almost ungracious to criticise it." Notwithstanding, the reviewer continued, "He has given a very faithful and not unpoetic translation. At the same time, we cannot pretend to think that the effect produced is at all comparable to that of Dante's magical cadence." To be fair to Sir Samuel, his approach to translation appears to have reflected a dominant view from late 19th century England of what was involved in that task, namely to produce a literal rendition, although his translation has been described as taking the dominant view to an extreme. The difficulties of rigid principles of literary translation apply also to the overly literal translation of testimony in a court from the language of the witness into the language of the court. And there was a time when the function of the interpreter in judicial proceedings was seen as requiring a literal approach. In Gao and the Queen decided in 1960, the High Court heard an appeal from the Supreme Court of the Territory of Papua New Guinea. An Indigenous Papuan had been convicted of murder. Evidence had been given of his admissions to a patrol officer made through an interpreter. The argument in the High Court was that the evidence of the admissions as interpreted was hearsay. That argument was rejected. In the course of his judgment, Justice Kitto described the role of the interpreter as not different in principle from that which in another case an electrical instrument might fulfil in overcoming the barrier of distance. And Sir Owen Dixon, Chief Justice, said, "I think that the translation word by word or sentence by sentence by the interpreter is not an ex post facto narrative statement of an event that has passed within the rule against the admissibility of hearsay, but is an integral part of one transaction consisting of communication through the interpreter." The courts have moved beyond the notion of interpreters as mere conduits. Their functions have been explored in judicial review applications in which asylum seekers have alleged interpreter errors before the relevant tribunal hearing. Justice Susan Kenny, in a frequently quoted judgment in Pereira and Minister for Immigration and Multicultural Affairs in 1999, rejected the notion of interpretation as a mere mechanical exercise. She observed that it requires both technical skill and expert judgment. She quoted from an American academic on the topic, M.B. Schulman, "No matter how accurate the interpretation is, the words are not the defendants, nor is the style, the syntax, or the emotion. Furthermore, some words are culturally specific and therefore are incapable of being translated. Perfect interpretations do not exist, as no interpretation will convey precisely the same meaning as the original testimony." Justice Kenny accepted that interpreting at a tribunal hearing need not be at the very highest level. Nevertheless, the interpreter should express in one language as accurately as that language and circumstances permit the idea or concept expressed in the other language. What she said was approved in 2006 in the Court of Appeal in Western Australia, and Justice Robert Smith emphasised the significance of communicating the idea or concept being expressed as distinct from merely substituting a word in one language for an equivalent in the other. Of course, the idea of concept-based interpreting brings with it a need for a clear understanding on the part of the judge, the lawyers, court officials and interpreters of what that term means. What is the interpreter doing in concept-based interpreting? In particular, there must be an understanding of the boundaries between transmission of concepts and a creative rendition of what the witness is saying that perhaps cannot and should not be attributed to the witness. Reflection upon the challenges of interpretation from one language into another and the challenges of communication between people speaking the same language but with different perspectives and understandings places the interpretation of written legal texts in the much larger context of the communication of meaning from one human being to another. More than one meaning may be conveyed by any given communication. The meaning that leaves the mind of the author may not be the meaning that arrives in the mind of the reader. If one goes to the dictionary to look up the meaning of a word, most words have more than one meaning. Many words have what we call shades of meaning, and when they are linked together in sentences or in the clauses of a contract or the sections of a law or the provisions of regulations or bylaws or legislative instruments, the way in which they should be read is not always susceptible of a single correct answer. Most disputed cases of interpretation, whether in contracts or laws, raise that kind of question, and sometimes it is of considerable difficulty. Contracts are not always well written, nor are laws. Meaning can be elusive. Principles governing the construction of contracts have been much discussed in recent decades in Australia. Some general principles, at least applicable to commercial contracts, are well settled as stated by 4 justices of the High Court in 2014 in Reinhardt and 2019, in Reinhardt and Hancock Prospecting. They said it is well established that a commercial contract should be construed by reference to the language used by the parties, the surrounding circumstances and the purposes and objects to be served by the contract. This has obvious resonance with the injunction to construe statutes by reference to text, context and purpose. In Electricity Corporation and Woodside Energy Limited, in the joint judgment of Justices Hayne, Crennan, Kiefel and myself, we said the meaning of the terms of the commercial contract is to be determined by what a reasonable business person would have understood those terms to mean. That approach is not unfamiliar. As reaffirmed, it requires consideration of the language used by the parties, the surrounding circumstances known to them, and the commercial purpose or objects to be secured by the contract. Now, that statement does not lay down a pathway to a uniquely correct answer in the construction of a commercial contract. It necessarily involves evaluation of constructional possibilities against a constellation of factors. And constructional choice often arises in contested contract cases. There has been a debate about whether the existence of such choices, sometimes called ambiguity, should be identified before the court may have regard to surrounding circumstances and the object of the transactions. A statement somewhat to that effect had been made in a special leave application in Western Export Services v. Jura International Proprietary Limited in 2011. But as Justices Kiefel and Keane pointed out in Mount Bruce Mining Proprietary Limited and Wright Prospecting Proprietary Limited in 2015, statements made in the course of reasons for refusing an application for special leave create no precedent and are binding on no one. And Justices Nettle and Gordon and myself agreed with that proposition. The High Court's not finally determined the question, but my own view, for what it is worth, is that it is difficult to disentangle the identification of constructional choices or so-called ambiguities from the factual context in which the words of the contract were chosen. When it comes to authorial intention in contracts or other non-statutory instruments such as deeds of trust, there is a similarity between statutory and contractual construction. In Burns and Kendall, Justices Hayden and Crennan said that the approach taken to statutory construction is matched by that which is taken to contractual construction. Contractual construction depends on finding the meaning of the language of the contract, the intention which the parties expressed, not the subject of intentions which they may have had but did not express. A contract means what a reasonable person, having all the background knowledge of the surrounding circumstances available to the parties, would have understood them to be using the language of the contract to mean. Turning to the search for meaning in statutes and rules made under them, it is useful to acknowledge the reality of the law as a kind of societal infrastructure with some Heath Robinson characteristics. The common law or judge-made law has evolved case by case over centuries, and in that evolutionary process, some branches of principle have flourished while others have withered and died, and the transition can be untidy. So too with statute law. Some statutes are the product of considered and thoughtful deliberations of the kind that might emanate from a report of a law reform commission following a consultative process with the input of an advisory committee of experts in the relevant subject area. Others are jerry-built, put together in a rush to meet a perceived urgent social or political imperative. And some reflect inscrutable political compromises. In 1933, in an address to the Medico-Legal Society of Victoria, Sir Owen Dixon described the methods of a modern representative legislature and its preoccupations as an obstacle to what he called the scientific or philosophical reconstruction of the legal system. The law is not always coherent, logical, or clear in its meanings. Some statutes, of course, seek to achieve precision through prolixity. Any Act of Parliament or set of regulations which has ventured into extensive alphanumeric designation of the sections is an act or regulation that is in trouble, and there is a distressingly large number of them. There was a well-known scene in the film Amadeus in which the emperor congratulated the young Mozart on the performance of a new composition, but he had a reservation. The exchange in the film went like this: "Mozart, so then you liked it, you really liked it, Your Majesty." Emperor: "Of course I did, it's very good. Of course now and then, just now and then, it seemed a touch elaborate." When Mozart asked the emperor to explain his reservation, the emperor said, "Too many notes." Salieri agreed that there were too many notes. The dialogue finished: "Mozart, this is absurd." Emperor: "My dear young man, don't take it too hard. Your work is ingenious, it's quality work, and there are simply too many notes. That's all. Just a few and it will be perfect." Mozart: "Which few did you have in mind, Majesty?" Emperor: "Well, there it is." It's probably as pointless for judges and lawyers to complain that statutes have too many words as it was for the emperor to complain that Mozart's composition had too many notes. We must ultimately get on with the job of interpretation and application. As Professors Pearce and Geddes observed in their book on statutory interpretation in Australia, no matter how obscure an act or other legislative instrument might be, it is the inescapable duty of the courts to give it some meaning. Giving meaning to words and statutes very frequently involves making choices, and the choices made will determine their effects upon people, their rights, obligations, liabilities, powers, privileges and interests, and even their liberties. A conveniently apposite, if somewhat pedestrian example of choice-making in the meaning of a statute was the decision of the Supreme Court of the United States, delivered in May 2012 in Taniguchi and Can Pacific Saipan Limited. I happened to be present in the Supreme Court as a guest of Justice Ruth Bader Ginsburg at the time that the decision was delivered. It concerned the interpretation of a statute providing for the costs recoverable in civil litigation. The provision considered by the court entitled a successful party to recover the costs of, quote, an interpreter, unquote. The question was whether or not the meaning of the word interpreter related only to interpreters of oral testimony or covered translators of written texts. The Ninth Circuit, from which the appeal was brought, had held that, according to dictionary definitions and common usage, the term did extend to the translators of written texts. The Seventh Circuit, on the other hand, with a classical literary flourish, had observed, Robert Fagles made famous translations into English of the Iliad, the Odyssey and the Aeneid, but no one would refer to him as an English language interpreter. And the view of the Seventh Circuit was evidently endorsed by the majority in the Supreme Court, which allowed the appeal by 6 votes to 3. Well, it doesn't take much research to find a reference in a review of Fagles' work to his, quote, interpretive choices and the position he has taken in, quote, contemporary debates about Homeric interpretation. Of course, the word interpretation was there used in the literary sense, somewhat different from the context of the term interpreter in the Federal Costs Statute. Nevertheless, the usages illustrate two things: the nuanced meaning of the word interpretation and the creative character of the process it denotes. The reasoning on both sides in that case, in which actually Justice Ginsburg dissented, exposed value judgments about the proper scope of costs recovery. These were translated into purposive constructional choices. The case offers an occasion for reflection upon a statutory word coincidentally applicable to the activity of those who had to decide its meaning. It directs attention to the volitional character of statutory construction, less a process of discovery than a process of decision-making, a choice of an available construction, albeit subject to constraints. And in truth, I prefer the term construction to interpretation, as construction of meaning involving choice from available meanings reflects what courts actually do. I might add, being present when the judgment was delivered, Justice Samuel Alito, who had written the majority opinion, read out a summary of the judgment and observed at the end that a copy would be available in the English language in the registry of the court, and if people wanted the translation they would have to pay for it. Sometimes courts must interrogate usage, perhaps even in literary sources, to identify an available constructional choice before determining what it is. A good example was the judgment of Justice Nisi in the Supreme Court of Tasmania in Doyle and Maypole Bakery Proprietary Limited in 1981. The court had to decide whether a dead blowfly resting on an indentation on the surface of an iced cake displayed for sale at the bakery could be said to be, quote, contained, unquote, in the cake within the meaning of section 63(1)(ba) of the Public Health Act 1962 of Tasmania. That section provided that an article of food is adulterated when it contains a foreign substance. The judge resorted to Alexander Pope's poetic essay on criticism, in which the following lines appear. Knights, squires and steeds must enter on the stage. So vast a throng the stage can ne'er contain. Then build a new or act it in a plain. The word contain was applicable on that usage to something resting on a surface. So the blowfly was held to be contained by the cake and the cake to have been adulterated within the meaning of the Act. Now in this case, the constructional choice plainly served the purpose of the relevant provision of the Health Act. It was no more acceptable to offer for sale a cake with a dead blowfly resting upon its surface than it was to offer for sale a cake with a dead blowfly baked into its interior. The construction of statutes requires reference to text, context and purpose, and resort to purpose in Australia is supported by statutory rules of interpretation, as for example section 15AA of the Acts Interpretation Act of the Commonwealth and section 14A of the Acts Interpretation Act 1954 of Queensland. Sometimes the identification of a purpose underlying relevant legal text which might inform its construction is difficult, and that's particularly so in the case of statutes which have chosen language reflecting compromises between contending interests or goals. One example was seen in the decision of the High Court in Stevens and Kabushiki Keisha Sony Computer Entertainment in 2005. That case concerned the interpretation of a provision of the Copyright Act which provided for civil remedies against the vendors of circumvention devices whose purpose was to circumvent or facilitate the circumvention of technological protection measures. That term, technological protection measure, was defined and its construction was the subject of contention in Stevens' case. The justices reflected upon the influences affecting the evolution of the Copyright Act and the approach to its interpretation. In the joint judgment of Chief Justice Gleeson and Justices Gummo, Hayne and Hayden, they referred to the requirement to construe the Act according to its underlying purpose or object. However, they found very little in the way of useful indicators of the statutory purpose. The extrinsic materials gave no clear indication of how the bill for the amending legislation which introduced the relevant provision took the final form that it did. And they said, indeed, the very range of the extrinsic materials with shifting and contradictory positions taken by a range of interest holders in the legislative outcome suggests that the legislative purpose was to express an inarticulate or at least not publicly disclosed compromise. And they cautioned that to fix upon one purpose and bend the terms of the definition to that purpose picked risking a winner when the legislature had stayed its hand from doing so. Importantly, there is a caveat, a related caveat on the search for purpose, which was enunciated by the High Court in Australian Education Union and Department of Education and Children's Services in 2012, where it was said that in construing a statute, it is not for a court to construct its own idea of a desirable policy impute it to the legislature, and then characterise it as a statutory purpose. Similar issues arise in aspects of revenue law which reflect political compromises rather than the application of coherent principle, and this is especially so where some classifications of goods or services may be subject to a tax of some kind. So in the days before GST we had sales tax, and much time was spent by clever lawyers and courts determining whether certain goods or services fell within or outside classifications which attracted different rates of tax. Was an office chair which could be used for household purposes able to be classed as a chair of a kind used for household purposes? The late Justice Graham Hill and I asked ourselves that question in the full federal court in 1993. What were the essential characteristics of household chairs? That kind of case is one that would fall within the category well known to the law of an arid intellectual exercise. There was no Platonic form of household chair. This class of problem did not disappear with the disappearance of sales tax. The political compromises that underpinned the enactment of the GST legislation produced a number of cases reflecting the absence of a clear public policy underlying particular applications. In one case, for example, Justice Sundberg of the Federal Court had to decide whether a mini ciabatta was a biscuit and hence GST free, or something else and hence not. He held it was not. His decision was upheld on appeal by 3 justices of the Federal Court. 4 fine judicial minds and an array of legal advisors had to grapple with that question. Now, returning to a higher level of discourse, the term constructive act has been applied to the reading of texts generally, not just legal texts. Meaning is said to emerge from the reader's choice in a transactional zone which is defined by common conventions and codes. Interpretation of legal texts, be they contracts or statutes or other instruments, can be regarded as a class of constructive action operating in a transactional zone which is defined in part by legal culture and associated rules, conventions and practices. The general proposition was succinctly set out by Justice Michael McHugh in a passage from his judgment in Theophanous and Herald and Weekly Times Limited, which has been quoted on countless occasions. The true meaning of a legal text almost always depends on a background of concepts, principles, practices, rights and duties, which the authors of the text took for granted or understood without conscious advertence by reason of their common language or culture. In the process of interpretation of a statute, of course, the courts give priority to the ordinary meaning of the words. But the word ordinary is somewhat beguiling. Ordinary meanings, one would think, would be the kinds of meanings with which ordinary people, a very poorly defined subset of people, are familiar. In a frequently quoted passage from a judgment in 1991, Justice Mary Gaudron offered a democratic justification for the rule that the ordinary and grammatical sense of statutory words is the starting point for interpretation. She said, "The rule is dictated by elementary considerations of fairness, for after all, those who are subject to the law's commands are entitled to conduct themselves on the basis that those commands have meaning and effect according to ordinary grammar and usage." So what effect does the term ordinary meaning have on the process of judicial interpretation? It's perhaps too simplistic to say that it points towards a subset of possible meanings of words, phrases or provisions. A paper in the Yale Law Journal in 2018 considered how one could go about discerning ordinary meaning. The authors translated the term ordinary meaning into the more technical sounding combination ordinary communicative content, to what end is not clear. They argued that characterisation of a meaning as ordinary is really a question of legislative fact and could be determined by the use of computer-assisted, quote, corpus linguistics, unquote. That involves apparently computerised searches for patterns in meaning and usage of databases of actual written language. The usefulness of computer-assisted inquiries into ordinary meaning is highly questionable. Indeed, a word or phrase in a statute may have more than one meaning, each of which could reasonably be called ordinary. Perhaps the most important function of the term ordinary meaning, as the point of departure for interpretation, is that it points the judges to ways of reading a word or statutory phrase or provision which are unlikely to be surprising to those who drafted and enacted the law, or indeed to intelligent non-lawyers, of whom there are a reasonably large number in the general population. Perhaps it can be seen as a restraining guide to judicial choice. It can accommodate the reality that words and phrases can be read in more than one way, each according with common usage. In some cases, of course, common usage may include a sliding scale of meaning. Examples are relational words such as in connection with and association, or evaluative words like offensive and insult. There, the judicial task will not be so much a choice of different meanings as a decision about where on the sliding scale the preferred register of a meaning is to be located. Statutory construction, when meaning is contested, is not usefully described as the resolution of ambiguity. That term itself is ambiguous. It covers doubt or uncertainty, but is also attributable to words with more than one meaning. Statutory interpretation is all about choice of available meanings, and in some cases it may be that there will be only one available meaning. Choosing the preferred meaning of a statutory provision where choices are available is not like solving a simple linear equation, nor is it to be determined by computer-aided searches of usage databases. For those who want to lace their law with a little science, the choice of meaning of a statutory word, phrase or provision might be likened to the observation of a quantum system. Unobserved, the system occupies a number of states, superposed and limited by reference to a probabilistic wave function. Observation does not discover which state the system is in, it determines it. The superposed states collapse into one. A statutory word, phrase or provision whose interpretation in a particular kind of case has not been finally settled brims with all the constructional possibilities that its ordinary and not so ordinary meanings and shades of meaning offer, but under an umbrella of legislative and common law assumptions, presumptions, rules and principles. The umbrella covers possibilities from highly probable and frequently used core meanings to permissible but less used and less probable meanings. It is loosely equivalent to the quantum mechanical wave function. An interpretation like observation collapses the possibilities into one outcome. It does not discover the one true result. Speaking of assumptions and presumptions, which assist the task of construction, their role was explained in the 8th edition of Pearson-Getty's statutory interpretation. They said the courts approach the interpretation of legislation with a number of basic assumptions or presumptions in mind. These are sometimes designated rules, but this is misleading. They are but assumptions and give way in the fact of an indication in the legislation that it is to operate contrary to them. They are based on the expectation that certain tenets of our legal system will be followed by the legislature. They are grounded in the liberal values shared by lawyers and legislators with members of the broader community. Those values are based on abstract concepts of freedom and the sanctity of private property that people living in parliamentary democracies under the rule of law expect to be recognised and upheld. Now, to the extent that that passage reflects an expectation about the existence of liberal values shared by lawyers and legislators with members of the broader community, it may sometimes be questionable. There is a plethora of laws and regulations produced by our legislatures and the executive in the exercise of delegated powers, which adversely affect rights and freedoms, including freedoms of speech, association and assembly. The Australian Law Reform Commission in December 2015 produced a report on encroachments by Commonwealth laws on traditional rights and freedoms, particularly in the areas mentioned, and it disclosed a wide range of Commonwealth laws interfering with freedoms of association, assembly, speech and movement. And these may be multiplied many times when one adds in state and local government bylaws and rules and public authorities which have rule-making powers, including universities. Courts increasingly must decide whether the abandonment of expectations about the general acceptance of liberal values shared by legislators would necessitate the abandonment of a protective approach to construction based upon assumptions about legislative intention. One answer to that question is that the protective approach of the common law of statutory interpretation in relation to rights and freedoms and long-established principles has a small c constitutional character, which is proof against the ebb and flow of populist tides. But that answer is subject to a caveat. Even the common law cannot push the courts across the boundary which separates the judicial from the legislative function. It is that boundary and its connection to the concept of legislative intention which I now wish to mention. The boundary between the function of the legislature, which enacts the law, and that of the courts, which interpret and apply it, is not a bright, narrow line. Statutory construction does involve lawmaking within permitted limits to the extent that it involves constructional choices available on the text, constrained by common law principles and statutory rules of interpretation. The idea of legislative intention as a boundary marker was mentioned in Zing and Kai, decided in 2009, in which it was said in a joint judgment in the High Court that to attribute an intention to the legislature is to apply something of a fiction. However, what is involved here is not the attribution of a collective mental state to legislators. That would be a misleading use of metaphor. Rather, judicial findings as to legislative intention are an expression of the constitutional relationship between the arms of government with respect to the making, interpretation and application of laws. The preferred construction by the court of the statute in question is reached by the application of rules of interpretation accepted by all arms of government in the system of representative democracy. The constitutional relationship between the legislature and the judiciary, reflected in the common law constitution and for the Commonwealth of Australia in the written constitution, which is embedded in the common law tradition, imposes limits on the range of choices available to courts in the processes of statutory construction. By way of example, in Momsilovic and the Queen, the High Court considered Section 32(1) of the Charter of Human Rights and Responsibilities of Victoria, which requires that so far as it is possible to do so, consistently with their purpose, all statutory provisions in Victoria must be interpreted in a way that is compatible with human rights. And the case concerned the provision of the Drugs, Poisons and Controlled Substances Act, which deemed a person to be in possession of a substance for the purposes of the Act if the substance was upon any land or premises occupied by the person unless they satisfied to the court to the contrary. And this was in tension with the presumption of innocence, which was set out in the Charter. The court rejected an argument that the section could be read down as requiring the accused only to introduce or point to evidence of the fact that she was not in possession of the drugs on her premises. But that construction was not open on the text. And 6 justices held that the interpretive task imposed by the section accorded with ordinary principles of common law statutory interpretation, indeed a statutory analogue of the principle of legality. There's a similar provision in Section 3 of the Human Rights Act 1998 in the UK, and the House of Lords in Gaidan and Godin Mendoza 2004 decision took a somewhat different approach, saying that the interpretive provision was apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. Now, they deployed a number of what I call patrolling cautionary metaphors to ensure that this process of remedial interpretation didn't get out of hand. So the application of the rule had to be compatible with the underlying thrust of the legislation. It had to go with the grain of the legislation and not remove the very core and essence, the pith and substance, nor violate a cardinal principle of the legislation. No doubt very useful guides. But there may be seen in those cautionary terms a concern to limit the movement of the boundary between judiciary and parliament effected by the interpretive principle. Nevertheless, the interpretive function assumed by the House of Lords in Gaidan seems to me to have travelled beyond the common law principles of interpretation and what we would accept as a proper location of the boundary in this country. The principle of legality, which I've mentioned, denotes an approach to construction originally linked to an assumed legislative intention not to extinguish or impair fundamental common law rights and freedoms and principles without clear words, that is, words that leave no constructional choice. A textual source of the presumption is found in the judgment of Chief Justice Marshall in United States and Fisher, decided in 1805. And in that judgment he said, where rights are infringed, where fundamental principles are overthrown, where the general system of laws is departed from, the legislative intention must be expressed with irresistible clearness to induce a course of justice to suppose a design to effect such objects. Now that passage turned up in the 1905 edition of Maxwell on the Interpretation of Statutes, and it was quoted by Justice O'Connor in Potter and Minahan in the High Court, decided in 1908. The approach to construction enunciated in Potter and Minahan using that passage from Maxwell, derived originally from Chief Justice Marshall, was not confined to rights and freedoms, but extended to fundamental principles and the general system of law. And that generality was reflected in the statement of the High Court in 1990 in Ballog and Independent Commission Against Corruption, that where two alternative constructions of legislation are open, that which is consonant with the common law is to be preferred. The nature of legislation as an imputation based upon statutory text was affirmed in the joint judgment of 4 justices of the High Court in Project Blue Sky Inc. and Australian Broadcasting Authority, where their honours said the duty of a court is to give the words of a statutory interpretation the meaning that the legislature is taken to have intended them to have. And the court in that case referred to the presumption of legality as the presumption that in the absence of unmistakable and unambiguous language, the legislature has not intended to interfere with basic rights, freedoms and immunities. So we are not seeing legislative intention treated here as some kind of anterior reality that has to be perceived and then deployed in aid of construction. It is determined by reference to the correct or preferred construction of the statute. Ultimately, in Lacey and the Attorney General of Queensland, 6 justices of the court brought the presumption enunciated in Project Blue Sky together with a statement about legislative intention, where they said the legislative intention there referred to is not an objective collective mental state. Such a state is a fiction which serves no useful purpose. Ascertainment of legislative intention is asserted as a statement of compliance with the rules of construction, common law and statutory, which have been applied to reach the preferred results and which are known to parliamentary drafters and the courts. And of course, one of those rules is the principle of legality. The joint judgment in Lacey also discussed the concept of the purpose of a statutory interpretation, which we may distinguish from legislative intention. And it was said the application of the rules will properly involve the identification of a statutory purpose, which may appear from an express judged statement in the relevant statute, by inference from its terms, and by appropriate reference to extrinsic materials. The purpose of a statute is not something which exists outside the statute. It resides in its text and structure, albeit it may be identified by reference to common law and statutory rules of construction. And so the principle of legality, originally linked to the notion of an assumed legislative intention, may be seen as applicable to a process of construction which exposes that legislative intention rather than, or determines, imputes that legislative intention rather than working from an assumed legislative intention. There were 2 high-profile cases which I'll mention in finishing, which involve the application of the presumption of and the principle of legality in the federal court. They were Minister for Immigration and Citizenship and Hanif in 2007, which I sat on the full federal court in that case in Queensland, and Evans in New South Wales. In Hanif, the full court construed Section 501 of the Migration Act narrowly. That section defined the circumstances in which a person would not pass the character test and so be liable for refusal or cancellation of a visa on character grounds. A person would fail the character test if the person, quote, has had an association with someone else or with a group or organisation whom the minister reasonably suspects has been or is involved in criminal conduct. And Dr. Hanif had the misfortune to be related to some people who had engaged in terrorist activity in the United Kingdom. The court had to interpret the kind of association which would bring a person within the criterion. Was it good enough to be a relative or a friend of a person involved in criminal conduct? And the court said, having regard to its ordinary meaning, the context in which it appears and the legislative purpose, we conclude that the association to which the section refers is an association involving some sympathy with or support for or involvement in the criminal conduct of the person, group or organisation. The association must be such as to have some bearing on the person's character. Now that's actually an example of a relational term, association, with a sliding scale of meaning, being interpreted by reference both to purpose and also to keep it within bounds allowed by the capacity of the, keep it within the bounds to avoid the provision impairing the liberties of innocent persons. In Evans, the court was concerned with the validity of a regulation made under the World Youth Day Act of 2006. Under that regulation, a person could be directed not to engage in conduct causing annoyance to participants in a World Youth Day event. World Youth Day was a day in which the Pope was to be visiting New South Wales, and there were pilgrims coming from all over the world, and it was a big event in New South Wales, and there was a group called the No to Pope Coalition who wanted to distribute free condoms in protest against the Church's teachings on sexual morality. Anyway, under the relevant regulation, the person could be directed not to engage in conduct causing annoyance. The No to Pope Coalition challenged the regulation, and they succeeded. The regulation making power, which was conferred by the Act itself, was interpreted according to the common law principle of legality and found not to authorise a broadly stated regulation directed to conduct causing, quote, annoyance to participants in a World Youth Day event. So it was interpreted in such a way as to minimise unwarranted interference with freedom of speech. In conclusion, the search for meaning is not for the faint-hearted. There are few cases in which the inquiring judicial mind will, in a moment of recognition, see the one true answer. Generally speaking, the courts have a volitional role in selecting that meaning of a statute which best accords with its text, its context and its purpose. In so doing, courts must recognise that they are not uncovering the elusive butterfly of true meaning. Indeed, the butterfly may be not so much elusive as illusory. Rather, it is choosing the best meaning in the circumstances according to the common law and statutory rules of construction, and respecting the constitutional function of the courts in doing so. Thank you very much for your attention.